Trump's emergency powers. Are judges about to rein him in? President Trump's penchant for declaring emergencies is shaking up the federal judiciary, and the courts are now wrestling with whether to rein in his expansive use of executive power. But here's where it gets controversial. The sheer frequency of these emergency declarations raises a critical question. When does a leader's crisis-driven strategy cross the line into overreach? And this is the part most people miss. The legal battles unfolding in courtrooms today could redefine the balance of power between the presidency and the judiciary for decades to come. Since taking office in his second term, Trump has issued dozens of executive orders and proclamations. https://www.politics.policy. Trump makes broad use of emergency powers to advance policy priorities. OB 2378A4. Framing the U.S. as facing urgent crises that demand immediate. This approach allows him to bypass the slow, deliberative process of Congress and push forward policies through emergency authority, a tactic that critics argue sidesteps democratic checks and balances. For example, by declaring a national emergency to fund a border wall or to fast-track infrastructure projects, Trump has effectively used the emergency label as a shortcut to achieve political goals. Judges now face a pivotal decision. Should they treat these declarations as legitimate tools of governance, or are they being weaponized to circumvent the Constitution's system of shared power? This isn't just a legal debate, it's a philosophical one. Supporters might argue that leaders need flexibility to act swiftly in times of crisis, while opponents warn that such tactics risk normalizing authoritarian tendencies. And here's the twist. The courts. Do you think this is a necessary tool for leadership or a dangerous overreach? Share your thoughts in the comments below. Copyright 2025 Dow Jones Company, Inc. All rights reserved. 87990 CBE 8568118D5 EDDA 844 CS7 B1CD EB. Trump's tariff battle, a crucial court test. The impending court showdown over President Donald Trump's global tariff strategy is set to unfold on Thursday, marking a pivotal moment for its future. At 10 a.m. ET, a panel of 11 judges in Washington, D.C. will engage in approximately 45 minutes of arguments from both the Trump administration and two small businesses that contend many of his import tariffs are unlawful. These extensive tariffs are scheduled to take effect on Friday. Following a postponement of the most significant increases in April due to market instability, Trump has introduced a variety of tariff rates affecting around a dozen trading partners. While many of these rates echo the threats made in early April, some have been adjusted upwards, while a few have been slightly reduced. Businesses of all sizes have expressed that these tariffs have led to confusion and uncertainty, complicating their planning processes. The National Retail Federation highlighted in June that retailers typically plan their inventories 6 to 9 months in advance to meet seasonal demand. However, unpredictable and rapidly changing tariff policies are making it nearly impossible to forecast costs, place orders, and manage supply chains effectively. VOS Selections Incorporated, a wine and spirits importer, along with Plastic Services and Products, a company specializing in pipes and fittings, have taken legal action against Trump. They argue that his invocation of the International Emergency Economic Powers Act, IEEPA, of 1977, is overreaching, claiming he lacks the authority to impose broad global tariffs without congressional consent. In late May, the Court of International Trade initially halted the tariffs, determining that the import duties lacked any identifiable limits, and that the law cited by Trump in his executive orders did not grant him unlimited tariff authority. The court also stated that the tariffs did not satisfy the criteria for an unusual and extraordinary threat to the nation. Trump's tariffs, which have been applied to major trading partners, including Canada, Mexico, China, the European Union, Japan, India, Brazil, and several others, have been enacted under this law. The companies involved in the lawsuit assert Congress has not delegated any such power. The president's justification does not meet the standards set forth in the IEEPA. His claimed emergency is a figment of his own imagination. Trade deficits, which have persisted for decades without causing economic harm, are not an emergency. They further argue that IEEPA nowhere mentions tariffs, duties, imposts, or taxes, and no other president in the statute's nearly 50-year history has claimed that it authorizes tariffs. In May, the White House defended its position, stating that trade deficits have created a national emergency that has decimated American communities, left our workers behind, and weakened our defense industrial base. It's important to note that this court battle will not impact tariffs imposed by Trump under different laws, such as the 10% steel tariffs on the United Kingdom and the 50% tariffs on steel and aluminium affecting other global trading partners. These tariffs were enacted under various sections of the Trade Act of 1974 and the Trade Expansion Act of 1962. The companies involved also contend that such sweeping tariffs could be devastating for small businesses throughout the United States. While the panel of judges is not expected to deliver a ruling this week, it is likely that whichever side loses will appeal to the Supreme Court. This ongoing uncertainty has left consumers and businesses in a state of limbo for much of the year. This lawsuit is just one of many challenges facing Trump's tariffs and trade agreements, with at least a dozen other lawsuits either filed or in the early stages of litigation. In a related case filed this month, an orange juice importer warned that U.S. consumers could see prices rise by as much as 25% due to tariffs imposed on Brazil. Trump announced a 50% tariff on Brazilian imports, citing a trade deficit that is in fact a surplus. This steep tariff appears to be influenced more by political considerations, particularly regarding former Brazilian President Jair Bolsonaro and the treatment of tech companies, including Elon Musk's X. Even if the court rules against Trump's tariffs, the administration may still explore other options to maintain them. Trump could direct the Commerce Secretary and the U.S. Trade Representative to initiate investigations under Section 301 of the 1974 U.S. Trade Act against various trading partners, which would allow for tariffs to be implemented following the completion of these investigations. Additionally, he could utilize Section 232 of the 1962 trade law, which is already in effect for steel and aluminum tariffs. There is also a rarely used trade law, Section 338 of the Trade Act of 1930, which permits the president to impose tariffs of up to 50% on imports from countries that discriminate against the U.S. According to Alec Phillips, chief U.S. political economist at Goldman Sachs, this authority, which has never been used, limits the amount of the tariffs, but does not require a formal investigation. In an insightful essay on trade issues, Max Yoeli, a senior fellow at the UK think tank Chatham House, and Leslie Vinjamuri, president and CEO of the Chicago Council on Global Affairs, suggest that Trump could also collaborate with Congress to enact new legislation that would provide additional tariff authorities. However, they note that his administration has shown a strong preference for executive action thus far. They further state the president has many other tools to coerce states and pursue his objectives, including expanding his use of sanctions and export controls. While Trump could negotiate and finalize formal trade agreements, most of what he and his administration have labeled as deals thus far are not comprehensive pacts. Instead, they are framework agreements that lack detailed provisions, often announced via social media and followed by brief executive orders. However, it's crucial to understand that formal trade agreements typically require years to negotiate due to the intricate nature of both the U.S. and global economies. The United States alone has over 12,000 potential tariff categories across 200 trading partners, as reported by the financial services firm UBS. Any formal trade agreement could be approved by Congress without the need for court intervention. Correction. July 31st, 8:31 a.m. ET. A previous version of this article incorrectly stated the location of the Federal Appeals Court panel hearing arguments on Thursday. The correct location is Washington, D.C., not New York.